case, SBS sought an injunction against a former employee that had been employed on a fixed-term contract. The employee, Andrew Corbett, had been originally employed by SBS in 2012 on a 2-year fixed-term contract. That was subsequently extended by a further 2 years and extended again by a further year, so that it was due to end in mid-2017. Andrew Corbett in March 2016 resigned from his employment, and SBS subsequently went to the New South Wales Supreme Court to get an injunction stopping him from working in the media industry in Australia, stating that he didn't have a right to terminate the contract or to resign, and therefore couldn't go and work for other employers. He had received an offer of employment and entered into a contractual relationship with ABC and was intending on starting there in April. So part of SBS's claim was also to stop him working for the ABC. Ultimately, SBS were successful in their injunction.
So the argument that the employee, Andrew Corbett, tried to run in this case was that there was no termination or notice of termination in the contract, so therefore he was entitled to provide reasonable notice to terminate his employment, and he argued that that reasonable notice was 1 month. In this case, the court found that the parties had specifically negotiated for a fixed-term contract between themselves, and they hadn't included a termination clause or a notice of termination in the contract because it was intended that it would finish on the termination date in 2017. So the court found that there was no reasonable notice required and he couldn't terminate it on reasonable notice. Importantly, in this case, it's important to remember that the argument's only available for ongoing contracts that don't have a notice period in the contract. But when the parties have specifically negotiated for a fixed-term contract, there will be no notice period implied into the contract.
And it's, in my opinion, very clearly correct at law to say that, particularly given the circumstances of this case. But I think, as an aside, the court also noted that 1 month wouldn't have been reasonable notice in any event, given the seniority of his position, and it would have been more like 6 to 9 months anyway. So he, his conduct in just purporting to give 1 month's notice was in pretty blatant contravention of rights, and they were prepared to give an injunction because that type of loss is not adequately compensated in damages if he were to go off and work for ABC.